As Grant mentioned, I'm a partner in the Madison office of DeWitt LLP, and I'm the chair of the Bankruptcy, Insolvency, and Restructuring Practice Group. That means I work mainly with small businesses, and in my practice, actually some farms and agribusinesses as well, and some smaller community banks. And a fair amount of my work also comes in representing creditors in business-to-business transactions. A lot of my clients are clients of the firm for other reasons, but come to me when a customer isn't paying them, or it's clear that they're going down the path of insolvency. So I try to help those businesses figure out if they can get paid or how they can get paid from a business that might be running into financial trouble. So that is, I see it, I guess I would say, from both sides. But the bulk of my practice and my clients is helping small business owners navigate financial tight spots. Just a little bit of my background. I've always had a focus on representing small and mid-sized business owners. I like it. They're very invested in their businesses. It brings me a lot of joy to try to help them. And obviously they have dedication, drive, ambition, energy that is, above and beyond. So I always find it sort of inspiring to meet with them and work with them on trying to solve problems that they may encounter. I'm not going to be talking much about bankruptcy today. You hear a lot about that in the news, but frankly, it's just not the way things typically work in practice. I would say that I favor, and a lot of business owners and other parties favor, a more practical approach to these kinds of things when they come. It isn't ever a good idea to first look at legal options. That's usually the option of last resort. So I begin by looking for more practical options with the business owner and the main players on the other side. Usually that's a bank or a big secured creditor. Maybe it's key vendors and suppliers on what to do. But as Grant mentioned, I think the reason I was invited today is because a SCORE member had an issue where a business was sold or closed, and there were some trailing obligations of the business owner after that happened. And that brings up a good point, and it's one that I often see and end up discussing with my clients, which is, if you recognize that a sale or a wind down of the business may be in the future of your business, the first thing you have to do is understand where this could impact the owners personally, because it is difficult enough, I think, for business owners to face the wind down or sale of their business, but it can be insult to injury if after that process is concluded, they find themselves with unexpected obligations that they didn't anticipate. And sometimes you can't avoid that entirely, but even being able to anticipate it and plan for it a little bit helps in that process. So one thing I always tell people is you've got to get into the documents with your bank, with your suppliers, with your vendors, increasingly in the restaurant sector. Cisco Foods will not sell food to restaurants of a certain size or smaller without extracting a personal guarantee from the owners. Has to do with the restaurant business, and sometimes they don't make it. It's not as common in other sectors to see personal guarantees for suppliers, but that's important for the owners of the business to know if they're even contemplating this type of a process. Bank documents are the same way. I have business owners that say to me, well, I set up an S Corp or an LLC or a separate business entity, and that's who borrowed the money. But inevitably, in businesses of a certain size and scale, those banks are asking for personal guarantees. Some of those personal guarantees are backed by mortgages on property that the owners own themselves. And so that may or may not be a problem, but the idea is to make sure that you get into the documents and understand what's there so that there aren't any unpleasant surprises when it's too far down the road to change course. So it's important to understand the contracts with vendors. It's important to understand the contracts with the banks. And another common source of issues like this that I see are with credit cards. A lot of business owners may have an Amex or a Capital One business card or something like that that they use, that they have $20,000 or $25,000 of credit that they can use for purchases or to cover, gaps in cash flow and that. And the business card has on it the name of their business. But what they don't understand, if they go back and research the application, is that they have signed up to pay that debt if the business doesn't. So all those things are important to review and understand. I tell people you could do this in any event, even if things aren't in trouble. It's a good idea to once in a while take stock as owner of what your personal obligations are. And obviously, when you're presented with opportunities, if a vendor says we'll extend you credit and here's our standard agreement, just taking care to read those things carefully and make sure you understand them. And if you don't, or you have concerns, maybe talk to a mentor, or if it's really complicated, an attorney. And I know attorneys, that costs a lot of money, but sometimes having that peace of mind going in, especially if it's something where there's going to be a lot of money involved, is a worthwhile exercise. A couple of things I wanted to talk about just in connection with, looking at an opportunity to wind down or sell a business. There are two things I think it's critically important for a business owner to be thinking about if they feel they may need to go down that path. One is they have to control cash. They have to understand and control the cash flow in their business. A typical model we see is a 13-week cash flow, which is a calendar quarter. And having a 13-week cash flow that's well thought out and accurate is almost indispensable to any planning along these lines. You have to understand the sources and needs of cash in the business. Now, we say 13 weeks. Why? It's a little bit arbitrary, but a calendar quarter seems to be a pretty good horizon where companies can accurately project based on prior years and trends, a pretty concrete set of cash inflows and also expenses. When you get too far beyond that, depending on the type of the business, the reliability of those forecasts starts to degrade. So a 13-week cash flow is typically what we see. And yet it's a long enough horizon that you can plan and react to things over a realistic timeline to accomplish whatever it is you may need to accomplish. And then that's updated on a rolling basis, and actuals to forecasts are compared, and the final totals are adjusted. And this gives the business owner what I call their cash horizon. If the business owner is looking at a sale or wind down because the business owner is concerned about cash running out, which is something I do see, the further in advance they can find that cash horizon, if they sense that it's coming, the more help I can be and the more options they're going to have for a successful process. Every once in a while, I get a call or an email from a new client, or sometimes it's an existing client, and it's, today's Thursday and next Friday is payroll and we don't know how we're going to make it. Well, that's a very, very difficult situation for anybody to help with, and I hope nobody is ever in that situation. But usually what I see is a CFO or a controller of a business saying, we are not cash flow positive. We're in the red. It's on the slide, and if things don't turn around by a certain date or a certain time frame, the slide will go too far and we'll kind of pass a point of no return. So understanding the cash flow of the business is important, and controlling the cash is important. The other thing that's important to control is the flow of information. A lot of small business owners have, I would say, more deeply personal relationships with their key employees, a lot of times with key vendors and customers. And they sometimes have the urge in very much in good faith and honesty that when they recognize that a sale or a wind down of the business is going to be the way things are going, they want to share that information with those people because, they want to trust them and they want to, they just want to be honest with them. But often I am telling my clients, well, there's going to be a time for that. But if the information starts to get out there and you lose control of the flow of that information, it could do more harm than good, even to those people that, you frankly want to share it with. because if other not so loyal customers, get wind of that and start to just pull their orders, or if not so loyal employees say it's time to leave, and it's too early in the process, obviously that can be very disruptive to any wind down process. Or if the idea is to sell, maybe a buyer hasn't been identified yet, maybe nobody knows what that transition is going to be like to a new owner, and losing control of the flow of that information can do more harm than good in many instances. So I often am talking to my clients about understanding cash and controlling the flow of cash, and understanding the right time for announcing your intentions to certain people. In the early going, usually it's kept in confidence with a lawyer, accountant, or a consultant if one is brought on, and then somebody in a key position with a lender, if that's who we're talking with primarily about this process. And it isn't until later in the process, when we have things kind of thought out and a model and a timeline, that we start sharing with other people what those plans are. So those are the kinds of things that I see as being key to anybody who's thinking about this process. It isn't, obviously, there isn't any one size fits all type of process. I encounter all different personalities and situations. I would say that the most important thing to a business successfully navigating any troubled waters is a good understanding of the numbers. You have to have good accounting. I've seen banks where things weren't going that bad, but because they lost confidence in the numbers, they just didn't feel the information that was being generated. The financials, just the regular monthlies were, there's gaps and holes, and they're constantly cleaning up and refreshing. And that weakened the bank's confidence, where, if you had ironclad numbers and things were a little bit shaky, the bank would be more inclined to stay engaged and give further opportunities. But when numbers start to degrade in terms of reliability, then there's a degrade of trust. And it degrades the ability for management to be able to figure out what's going to happen next. So sometimes I come into a situation, and that is the biggest problem. It isn't even really the cash flow. It's an inability to carefully understand where the money is coming and going. So a lot of times I end up working with the client to try to improve that situation. Sometimes it means adding or changing personnel. Sometimes it means bringing in a consultant, an accountant for a short-term engagement to try to help get things back on track. So that's probably one of the biggest issues I see in these situations, and correcting it can help in so many ways. It helps the management better understand, and it helps the bank or the key creditors if you can give them some information and say, here's where we are today, but we have reliable numbers that show us that we're going to be here in so many weeks or months. Having that as a tool to build support with other key players, it's just crucial. I often go through cash flow forecasting, and in situations that are more dire, where cash flow just frankly isn't available to cover everything, then we have to start looking at paying things in a certain order. We have to, what I call, do cash triaging, which is, what's the most critical thing? Often it's the employees. If you don't pay the employees, if payday comes and the employees aren't paid, that's a crisis for the company, because the employees will not be there on Monday if they're not paid on Friday. Payroll taxes and sales taxes right there with it. And then on down the line with critical vendors. A lot of times we're negotiating with banks and key vendors to try to keep things working with cash flow. Sometimes banks will let things go interest only, or even defer payments. That's certainly something we've seen a lot of lately with COVID. Banks understanding the cash pressures of significantly reduced revenues. Banks have backed way off of their aggressive approaches in these kinds of situations, and we're getting a lot of grace, but that doesn't last forever. And so when the sales come back, the companies have to be prepared to update and go forward and use the additional cash flow to get things back on track. So it's been an interesting time these last 6 months, and actually court filings are significantly down across the nation. Bankruptcies are actually about a third or a half in some states of what they typically are just on a month-to-month basis. And it's because everybody's in a holding pattern. Banks are not aggressively collecting their debts. They're kind of waiting and seeing. Business owners, the revenues are bad, but they're reaching concessions with landlords and lenders because those landlords and lenders, it doesn't do them good to get aggressive because, how are they going to collect their money if things go bad? So it's just been a very difficult time, but we haven't seen a lot of businesses go into formal bankruptcy or restructuring proceedings. I think there's probably been some that wind down or close without that process, which is also typical. I think where the challenge lies is when everything kind of comes off hold, probably in the second or third quarter of next year, and how quickly cash flows come back and people can make up the ground that were lost and satisfy, some lenders and landlords to get things back on track. But I think we'll probably see an uptick in some of those when that comes around. But I think, a lot of businesses that are understanding their cash flows and communicating with their key constituents are going to be able to restore things once revenues come back. And just the last thing I was going to just offer a couple comments. A lot of times I'll start a conversation with a client and they'll say, what about bankruptcy? What about receivership? They always want to know about those options. And I always kind of back them off and say, look, you don't want to be in one of those situations unless you have no other choices. I have business owners or individuals that come in and say, well, what I need is a bankruptcy. And I said, well, a bankruptcy is not an end in of itself. It's a means to an end, and it's not always the best. But I often just kind of tell them a little bit about what those processes could do. It's a question I get very frequently about what you can and can't do. One thing that we hear a lot about in Wisconsin are what we call Chapter 128 receiverships. And a 128 receivership is a state-run, state court receivership. It's not a bankruptcy. And it only has one outcome, and that is the sale of the business or its assets. It can't be used to restructure and merge with existing ownership. So sometimes companies use that because one creditor or one party is being overly aggressive and not playing ball with a plan for an out-of-court restructure or sale or wind down. And so that process is used because the first thing that happens is the court stays all collection activity and the company gets some breathing room, usually to work with the receiver and a broker or consultant to run a sale process that's orderly. So we see that quite a bit here when a company wants to sell and there's pressure from some key player that they need to hold off while they run the sale process. And then obviously you hear a lot about Chapter 11 bankruptcy. Those processes are pretty complicated and expensive, although as of February of this year, we have a new type of bankruptcy reorganization that is specifically tailored for small businesses, and it avoids a lot of the hurdles and expenses that were part of the Chapter 11 bankruptcy process previously that made that unrealistic for small businesses. So this year, starting in February, we started to see these cases come through. It's still kind of in a learning phase and a test phase, but it does seem to be working, and smaller businesses have a newer, lower cost, lower or higher success rate option available to them. But essentially, the Chapter 11 allows the smaller company of any size to restructure its balance sheet, restructure its debts, in some cases, eliminate debt or extend amortization of debt to improve cash flow, improve the balance sheet, and emerge as a financially healthier company. It can also be used to sell assets, and sometimes that's a part of it. So that gives the business owner the most options and flexibility in terms of either a sale or structuring. But it's a very complicated process, and it's a process of last resort if you can't work deals with banks and vendors and suppliers, and you're not getting what you need in terms of concessions. Sometimes you have to use a process like that to force it. But the key to that process is going in. You have to have a cash flow forecast that says, even if I accomplish all the things I think I can accomplish in that process, I'm still going to be able to pay the bills. So that's a key factor too. You can't just dive into that and say, well, I'm going to file this thing and hope for the best. But if you don't have an understanding of how you're going to merge and that there's going to be enough improvement with that process, that's never going to work. So I saw a question come through, so I want to look at it. And it was from Bill. Bill asks, are you seeing much in the way of a deed in lieu of foreclosure with real estate businesses? I do see that sometimes. I will tell you that deed in lieu of foreclosure works where there's a single mortgage on the property, there's no secondary mortgage or line of credit behind it, and there's no delinquent property taxes. So if it's a really clean situation and everybody agrees that it's best just to basically hand the keys to the bank, I do see that sometimes. An issue with that, though, is, oftentimes the owner says, well, I think I'm leaving equity on the table. I really need to sell this. Banks will be okay with that if an appraisal or some professional says, yeah, that's right. And often they'll put it on interest only, or even let the interest accrue if there's significant equity there. And then a sale is the better route because it gets the bank paid and maybe gets a little money for the owner. A deed in lieu is kind of a narrow set of circumstances where everybody kind of agrees that the value of the property and what the bank is owed are relatively close, or that, the time and cost of a sale would not yield a significant enough difference that it would be worth that time and cost. And by cost, I mean, a broker fee, 6 or 7%, whatever it might be. And then the marketing time, if it's going to be 4 to 6 months, you're talking about additional accrued interest and things. So the other risk of a deed in lieu is the deed in lieu might clear the debt for the business, but if there's a personal guarantee of that, that there has to be some agreement as to what the valuation is. If the bank doesn't agree that the value of the property that's being deeded is equal to the debt that's being retired, a guarantor might be on the hook for that deficiency. So there needs to be a clear understanding of the deed in lieu. And the next question is the bank motivated because of the right of redemption for 6 months? I think that's true. I mean, in a non-consensual fighting it out with the bank process, the bank is left with basically one option, and that's a foreclosure in state court. And if the bank thinks it's going to be paid from the sale of the property at auction, they can opt for a 3-month redemption period. And if they opt for a 3-month redemption period, they have to waive their right to seek any deficiency following the sale. But that doesn't apply to guarantors. So if the LLC, land holding company, is the owner, they say, yeah, I'm going to waive the deficiency. I won't collect from the LLC, which isn't going to have any assets or income after the sale anyways. But they can still go after an individual guarantor on that note, even though they waived the right to collect from the borrower itself, which in that case would be the LLC. So they can usually get it down to 3 months. 6 months if they want to retain the right to deficiency. That's often the case when the individual is the owner of the real estate, because they figure they can probably get the individual to pay some more on that deficiency. But yes, I mean, the redemption period obviously slows things down for the bank. And if they can find another way consensually to get that done faster without having to wait that 3 months following the foreclosure judgment, that's usually in everybody's best interest.
Craig, one question you brought up earlier, the personal obligation for a balance on a business credit card. Is that standard practice, or are there some credit cards that are different?
Yeah, that's a good question. I will tell you that it's my typical understanding that if you open one of these business cards, sometimes it's done through an online application, sometimes it's done over the telephone. And I fought this battle for years, and in almost every case, they're going to try to stick that to the individual owner. And it's not always as clear as you would like it to be. It's not always, here's the application for the business, and here's another piece of paper that says personal guarantee on it. This is true in ag credit a lot too. A farmer has an LLC or a corporate farm, goes in and borrows money on a line of credit with a cooperative or an ag financer. And there's two signatures there. One says I'm the company, one says I'm the individual. Sometimes it's just one, and it just has a line below that says I'm also taking individual responsibility for this. But I will just say, as a general rule of thumb, and I tell my owners, anticipate that if this is not paid, they will try to seek repayment from you. And a lot of times I can beat it back and negotiate it to something smaller, because there isn't ironclad concrete paperwork that says that it's the individual's responsibility. And, also depends on the wealth of the individual being sought for payment and how much money is at stake. But I just tell people, if you have that, and again, sometimes I see it, it's very clear, in bigger businesses especially, if the front office person took out a credit card so that the business can use it, I wouldn't expect that person to be personally responsible. But in smaller businesses, the identity of the owner and the business are a little bit blurry in the eyes of the credit companies.